Did you know that non-competes are now officially completely illegal? Well, kind of. Let me explain in this video and catch you up to speed. Hi there, if you are new to my YouTube channel, please subscribe. And my name is Paige Griffith. I'm the CEO and lead attorney behind The Legal Page. We are an online legal education platform and contract shop for small businesses. We help you get legally legit in no time without breaking into hives. On April 23rd, 2024, the Federal Trade Commission, or FTC, better known as, issued a final ruling that banned non-competes for all for-profit businesses. The final rule defines a non-compete as any term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting employment or operating a business in the U.S. after the current employment ends. It also prohibits all functional equivalents of non-competes, such as overly broad non-disclosure agreements and non-solicitation agreements. So, no non-compete clauses in employment contracts, and you can't have an employee sign a separate non-compete agreement. Remember here, independent contractors couldn't and never will be able to be subject to non-competes anyways. The final rule is supposed to take effect 120 days after the publication in the Federal Register, so likely sometime in September 2024. Once in effect, employers are prohibited from entering into or attempting to enter into new non-competes with any worker. Additionally, employers must notify current and former workers that their existing non-competes are no longer enforceable. There is just like one limited exception to this, and that's with senior executives. There's always a exclusion in some of these rules. And those are for those who earn at least like $150,000 plus and are really serving in policymaking decisions at your company. Here's the thing. This seems to be a big win for workers. There's an inherent imbalance of power between employers and the individual workers and employees who serve at their discretion. And federal regulation across the board is really one way to adjust for that. For employers, though, this is really a bummer, right? You can't contractually do anything now to prevent an employee from competing with your business. And they probably learned a lot from working for you and gained a lot of trade secrets from your business. Legally speaking, though, what I anticipated would happen has happened. There are already 2 lawsuits challenging the FTC's authority to issue this ban. That would be Ryan LLC versus the Federal Trade Commission. That was filed right away in April in 2024. And the Chamber of Commerce of the United States of America et al. Versus the FTC. That was also filed like April 24th, 2024. Both suits are arguing that the FTC has exceeded its authority. Basically, they said that the agency didn't have the power to issue the ban. And even if it did, a categorical ban on such agreements wasn't lawful. It's honestly quite interesting in my opinion, because the FTC ban is really the first federal sweep to make such a policy on non-competes. This was already handled at the state level, and there are tons of cases and precedent in certain states regarding non-competes. States like Washington really do not favor non-competes, while states like Montana have allowed them. But the FTC isn't going to issue a crazy ban like this that is sweeping across the board without feeling like they have the authority to do so. Even some of their spokespeople have said that our legal authority is crystal clear, and they address non-competes that curtail Americans' economic freedom. It's really at the very heart of our mandate, and the FTC looks forward to winning in court. Overall, given the legal challenges already underway, there is a significant possibility that the final rule may be delayed or even struck down altogether before it takes effect. And we've got some politics at play here. No kidding. Depending on political parties in power and their stance on laborers' rights and business rights, this could be interesting if the change in the executive branch were to occur in the next year. But of course, it's got to go up through the federal court chain now. So the filings are in federal district court. Those will be heard, and then to the appellate court, and then maybe to the Supreme Court, which we all know right now has been pretty hostile to such employer regulations. So legally speaking, what should you do right now as a small business owner, right? Like, do you have non-competes? Do you not have non-competes? It's a bit concerning on how you are now going to protect your business and your trade secrets and intellectual property from someone coming to work for you and then basically take your business model and go create their own to compete with you. That's not fun for anyone. If you're a nonprofit business, this FTC ruling doesn't apply to you. So you can still have non-competes there. You can still have non-disclosure agreements, NDAs, which would protect your trade secrets from all being shared, whether that is an employee or a contractor. Both can sign NDAs. And you can also just have this as a confidentiality clause in your actual agreements with your ICs and your employees. You can also use non-solicitation clauses if drafted properly to keep your workers from stealing your client roster and team members so they can't solicit your clients. But those have to be narrowly construed. You have to have time frames on them, so on and so forth. And finally, remember to protect your intellectual property. File copyright registrations with the US Copyright Office, file trademark registrations with the USPTO, lock down your ownership of your brand and your content so that workers can't take it and use it for their next business endeavor. To summarize, the FTC ban on non-competes is a federal-wide all-state ban for non-competes in for-profit businesses. But we've got some lawsuits in the works now, and it will probably take some time for this all to sort out. My best suggestion is to talk to an experienced employment lawyer in your state to ensure that you handle non-competes with your employees properly. And especially if you have some non-competes underway right now with your employees that you aren't sure what to do with, I need you to figure out with an employment lawyer what you should do with those. And if you're interested in hearing more from me about contracts, specifically 3 of my best kept contract secrets and 4 things you can do right now to better protect your business from your clients and any what-if situations, please head over to my free legal class at contractclass.com. Thanks so much. I hope you learned a lot about non-competes and follow along, subscribe to my channel, and I'll catch you in the next one.